evening, ladies and gentlemen. Welcome to this session of Maritime Knowledge Lecture Series. And today we have a talk on the maritime dispute resolution, India and the global perspectives. Well, maritime disputes or maritime aspects are very important and significant for a country like ours, which has such a vast coastline, and India's maritime trade is continuously growing. Just to give you a figure, we spend around 100 billion US dollar annually in freight charges alone, and there are parties involved in this figure. So many parties, there could be shipping parties, cargo parties, insurance parties. Sometimes disputes emerge out of this, not only from the inception stage of the contracting, but negotiations and thereafter arbitration, mediation, and so many different aspects of it. So today we have a renowned expert on this subject. In fact, two renowned experts on this subject. One is an academician, Professor Garg from NLU Delhi. He is also the executive director of the Center for Transnational Commercial Law, CTCL, and is also the center head for a Center for Incubation, Innovation and Entrepreneurship, which is very important for young audience like you. Startups and innovation in the field of law is an important aspect, and Professor Garg, I would request him to touch upon these aspects when he addresses the audience. And we have none other than Professor Advocate Ratan K. Singh, a senior advocate based in New Delhi, and is also an international member of Keating Chambers, London, and is honorary professor currently at Manipal Law School, but many other international and national law institutes and agencies. Advocate Singh is also the founder and chairman of India's branch of Society of Construction Law, UK, and director of India's branch of Chartered Institute of Arbitrators, UK. Mr. Singh is also impaneled as an arbitrator on the panel of Singapore International Arbitration Centre, Asian Institute of Alternate Dispute Resolution, Kuala Lumpur, and Delhi International Arbitration Centre, as well as the Indian Council of Arbitration, ICA. He is a postgraduate in geology. Thereafter, he did his LLB from Campus Law Center, Delhi University, and joined the Indian Bar way back in 1996. He is one of the very, very illustrious expert in this field, with his international arbitration fellowship at the FCI, Fellow of Chartered Institute of Arbitrators, UK, and many other fellowships. So I will not stand in between, although a little bit of rain has stood in between you and these two expert speakers. There was a little bit of rainfall before we started these proceedings, but I am not going to stand further. May I now request Professor Ratan Singh to address the audience.
Good evening. Thank you for the introduction. This gathering here reminds me of a gathering I was part of for 3 continuous days from 9 a.m. to 5 p.m. in Stellenbosch in South Africa. Stellenbosch is 50 kilometers from Cape Town. That was May 1st, May 2nd, and May 3rd, where 60 legendary personalities from all across the globe sat within closed doors and discussed about jurisprudence and development of jurisprudence of construction law. And by the way, shipbuilding is all about construction law, you all know this. these kind of gathering where people who have practiced the subject, who are practicing the subject, who have mastered the subject, when they sit together and deliberate, this really is very, very encouraging sign for any industry for which such a gathering assembles. What is this? Am I a professor? Am I a lawyer? Am I a technician? I am lawyer by profession, teacher by heart. I have given lectures in many universities all across the globe, including Harvard, Oxford, and blah, blah. I got started LLM in 2 universities in India. Now I am about to start teaching construction law in OP Jindal. This is what the invitation is as a visiting faculty. I am honorary professor there. I love the subject I practice, and this is how I love teaching. Chartered Institute of Arbitrators UK, which promotes maritime arbitration in big way, had a Reebok lecture 2025. Every year they will organize lectures, and one eminent personality from arbitration world would give the lecture. This time, Sir Robin Knowles was the speaker, eminent speaker. And he talked about something which is very close to my heart, and that is what I thought I'll start with today and I'll talk about. That is diversity in arbitration. Here, diversity does not mean, we generally people think that you should have equal representation of women. Here he talks about inclusion of non-legal professionals from industry in arbitration world. Unfortunately, in India, almost all arbitrators, all chairpersons of the arbitral tribunals or sole arbitrators for all big matters, arbitrators are all retired judges. I sit as arbitrator, I wear both the hats as counsel as well as the arbitrator. I sit as arbitrator with all retired Supreme Court judges, Chief Justices, High Court judges, and so on and so forth. Question is whether such people of legal background, having no idea about the industry and having no domain knowledge, are fit to be the arbitrators for specialized subjects like maritime law, maritime disputes, or maritime or construction disputes, or merger acquisition disputes? Answer is no. I say it on open platforms in front of judges, in front of sitting judges, sitting Chief Justice of India. I have been saying this. Fortunately, and if you see globally, your maritime arbitration is still largely immune from legal arbitrators or arbitrators of legal background. If you see globally, even if you have lawyers sitting as arbitrators in those popular jurisdictions and popular seats such as London or New York, they are maritime lawyers or lawyers turned judges who retired but they had practiced maritime law. One good thing about maritime arbitration, which I always feel, is that maritime arbitration still largely follows ad hoc arbitration mechanism. It is not as institutionalized as commercial arbitrations, other commercial arbitrations, or other form of arbitrations. This is a good sign. And why it is so? Because globally, at least in those popular sought after jurisdictions and seats, largely arbitrators are having maritime industry background. And that's why they didn't want it to be institutionalized in such a way where institutional rules really takes away the flexibility of ad hoc arbitration. Ladies and gentlemen, ad hoc arbitration is the purest form of arbitration. Few years back, I was just speaking in a conference in London, and our worldwide president was sitting beside me. He said we should promote institutional arbitration. I said I oppose this statement. Arbitration was never meant to be regulated by third-party agencies or institutions. Maritime arbitration is one of the oldest form of arbitration. In fact, if you see international arbitration, it has its genesis in maritime disputes and maritime arbitration when vessels from one jurisdiction would go into another jurisdiction. How those disputes were decided? There was no requirement to go to any institution. There was no requirement to appoint arbitrators through those typical institutional mechanisms which you see today. You have sailed your vessel at a particular destination, you go there, you have some dispute, it is chartered party dispute or bill of lading dispute or any other form of dispute. You go meet somebody there, some senior level maritime professional. You say, hey, we have some dispute. Can you tell us which of the two is correct? That gentleman knows the industry, he knows the business, he knows the dispute, he knows what are the answers. He will immediately tell you, you are right, not him. You have said whatever you say, we are bound by that. That is how arbitration started. This purity has been maintained by maritime dispute and maritime arbitration world to larger extent. Even if you see LIMA, that LMAA, the London Maritime Arbitrators Association, it's not like an institution which is ICC Paris. Yes, ICC Paris does administer maritime arbitration. London Court of International Arbitration, LCIA, does administer arbitration. SIAC does administer maritime arbitration, but there are very few. And if you look at LIMA, look at the way they do it, or you see MA, that is the Maritime Arbitration Association of United States, how they do it. For small size claims, they have some terms, they call it terms, some rules, provided you adopt them. Otherwise, what happens is this. They have a panel of arbitrators who are selected with due deliberation. Even when in Singapore, they started maritime arbitration institution, they gave a rethink to it to make it more ad hoc than institution. And whole idea is this, because one of the primary reasons why historically maritime disputes are going to arbitration and not to court is confidentiality. In this industry, confidentiality is something everybody is very, very concerned about. So this purity has been maintained in this particular industry globally. Now you have, Japan has come out with a good destination, Hong Kong has come out with a good destination. But question is, what has led the path is London or the New York. Issue to be deliberated here. And this is what I urge all of you. To give a thought, to take arbitration as an alternate or additional career option. All of you sitting here know maritime industry more than any judge would know, or more than any lawyer who doesn't do a maritime law would know. So why it is that the professors sitting in room here do not think about having maritime arbitration as a career option in 3 capacities at least. 1, you can be cited as expert on maritime law in maritime arbitrations. Role of experts is very, very important in this particular industry of arbitration. You have to. Who better than the law professors who can give their views? Opinion, it is called opinion when you are cited as expert. Why can't you give your opinion on a particular aspect of maritime law? Think about it. You can sit as arbitrator. When I say this, and it is a good career option, I must say this. It gives you tons of money, particularly in this country. Tons of money. Even if you have Schedule 4 coming in, but big arbitrations are not governed by Schedule 4 of Arbitration and Conciliation Act. It gives you tons of money. Now, when I say this, I am conscious of one fact, that one question which crosses the mind of people who are otherwise well versed with the subject, who have mastered the subject, who are very good in understanding the maritime industry, maritime dispute, solutions to maritime disputes, they would say, and this is my experience, they would say, I know my industry, but I don't know arbitration. And that pulls you back. So I thought I'll talk a little bit about this side of, practice side of arbitration. It is very easy. And there are some industry professionals who sit as arbitrators, but they have sometimes fear of unknown. And that fear of unknown is, like I'll tell you, what if you have a contiguous lawyer, he starts talking about a nuanced aspect of Civil Procedure Code or Evidence Act. You will say, forget Evidence Act, forget Civil Procedure Code, it doesn't apply to arbitration, but he'll say principles apply and so on and so forth, all those nonsense. But he has started troubling you. How to deal with them? Second, the moment one of the sides would say that I want to go for cross-examination, people from industry who do not have legal background or judicial background, they have some reservation about conducting cross-examination or allowing cross-examination to happen in arbitration, because they never had occasion to either do cross-examination or conduct cross-examination as a judge. Now, how to tackle all of this? And I'm sure most of you sitting in this room would have occasion, must have had occasion to observe. So, before I go to this, let me tell you how cross-examination is so simple. In fact, I had occasion to give a lecture in OP Jindal on 10th of May. 8th I came back from South Africa. I remember 10th I was there. Akash, you were there, I think, yeah. And I gave 2 hours lecture on cross-examination. We can have one session separately on cross-examination. All fears will disappear from window. I must assure this to all of you today. It is just that one session where we talk about, it should be a structured talk on cross-examination. That's it. Nothing less, nothing more. Now, question is, most of you would have had occasion to observe arbitration in India. And somebody asked me the other day how to learn cross-examination, and she was a law student. I said, very simple. If you don't want to have a structured training program like 2 hours, 1.5 hours, simple. First, read the file, know the facts. First thing. See, we must understand and appreciate one thing, that arbitration is primarily, substantially about fact-finding. Law has very limited role to play. This fear of awareness or unawareness about law should be again thrown out of window. Little law, if it will have any application, both side lawyers. You are in adversarial system. India, we follow common law system, which is adversarial system. So why the lawyers are there? They'll bring the laws. And anybody with common sense can say which of the two sides is correct. That's it. Which law is binding. So you should not have this concern about knowing or not knowing the law to that extent, nuanced law. If at all it comes to that, you can ask somebody, one of your colleagues or a junior, to do some research, that's it. But I'll tell you one thing. In common law jurisdictions, like India, like UK, so it starts, all common law countries, primarily, we follow adversarial system, where both sides play and arbitrators are referee. And they have to decide which side won the game. But there is a caution. This was historically the definition of adversarial system of law. This definition had changed, and UK has taken the lead. If you see, if somebody had okay, see, so like in India, you have called something called, all litigations in court are conducted by referring to something called Civil Procedure Code. In UK, they also have Civil Procedure Code. Only difference is they call it CPR, Civil Procedure Rules. There, in recent past, there have been 2 major amendments in their CPR. One was on the recommendation of Lord Wolf. He was a judge there. And thereafter came Jackson report. Again, Lord Jackson's, Rupert Jackson. I met both the gentlemen. I know Rupert Jackson very well. What they did by way of those large-scale amendments, they brought in relevant aspects of the procedures which are inquisitorial from civil law jurisdiction. So we all know here, sitting here. So we in world, generally we follow 3 legal systems. In common law countries, as I said, common law countries, India, Singapore, Malaysia, Australia, New Zealand, USA. But even we follow common law system where we follow adversarial system. But then you have civil law jurisdictions, civil law like continental Europe. But they are even in Nepal. Nepal follows civil law jurisdiction. Japan follows civil law jurisdiction. China follows civil law jurisdiction. Entire Latin America follows civil law jurisdiction. What is the difference between the two? If you try to think about it, arbitration will become very, very interesting phenomena for all of you sitting here. And I must tell you, in fact, this reminds me, this 1st of July and 30th of June, I spoke in a conference in Kuala Lumpur. There they celebrate something called Kuala Lumpur Arbitration Week. And I was invited to speak in their main session where the topic of the session was behind the scene. So I had to give arbitrators' perspective. One gentleman was from US, I was there, one from Hong Kong, one from Malaysia, and one judge, Supreme Court judge from Malaysia, was moderating that. Now, and one of the questions which I answered there was this. Datuk Mary Lim was the moderator. She had asked a question. How arbitrators balance practicality vis-a-vis the legal principles? I said, you have to simply think about technical arbitrators. Technical arbitrators are, I would say, purest form of arbitrators. Just that, why I am telling you this, that just that little bit of idea about arbitration as a process and little bit of law, very basic, one day session enough, is required, that's it. Why I say this? Arbitration was being done and decided by everybody from industry. Historically, all trades, maritime on the top, by all industry people. Then something happened. God invented lawyers. When God invented lawyers, then lawyers started talking about their own language. In order to look different from others, in order to have supremacy, they started talking about inclusion of law in this dispute resolution mechanism, and this is how ancestral model law, on the basis of which you in India have enacted Arbitration and Conciliation Act 1996. Arbitration and Conciliation Act 1996, when it was enacted, it was nothing but verbatim reproduction. How much time I have so that I know where is my limit?
There's no problem, sir, but audience will be more interested to see how maritime growth, India's maritime growth,
I'll tell you.
And maritime.
Okay, so I'll come to that. So let me finish this for the moment. 1996 Act was nothing but verbatim reproduction of ancestral model law. And ancestral model law, so even the section number here was the same article there. Now what happened was this, if you see article 28 there, ancestral model law, and section 28 you have here in India, it says arbitrator has to decide the dispute in accordance with law. This is where problem started. Disputes were supposed to be decided on the basis of the industry norms. Now, Article 28 also says industry trade uses customs. But tell me one thing, which retired judge know about the industry practice, industry uses? So what they do? They'll only talk about law. You have lawyers appearing from both sides, they'll only talk about law. So therefore, there has been a dilemma in the arbitration world. Which of the two categories of arbitrators are best suited to be arbitrators? One, technical arbitrators, or legal arbitrators? Technical arbitrators with little background of legal side, very little background, are best suited. So I'll tell you how it works. When disputes come before you, when pleadings are brought before you, what do you do there? You as a technical person, you as a person who knows the industry, your focus is to understand how this particular dispute arose. You can immediately visualize how it would have happened because you have facts before you. And then you say which side is right, which side is wrong. Then lawyers will come. How many of you know Hindi? Generally people would know Hindi. वो आएंगे रायता फैला देंगे. What these people will come and say, they will not understand how dispute arose. They will not understand which side is right, which side is wrong. What they will do is, it is barred by estoppel. It is barred by limitation. They have waived their rights. Now, question therefore is, how to deal with such a situation? Mandatory laws can never be overlooked, but they are very few. Now, I have been asked to talk about the growth. I'll tell you. Now, this complaint which I am talking about, what happens in arbitration in India? Arbitrators will never read the file. I am talking about judges, retired judges and people of legal background. They will never open the file till the time final arguments are heard, are being heard, or maybe sometimes later at the time of passing of award. And whatever comes to their mind, they'll do that. Internationally, this doesn't work like this. When I sit as arbitrator, I would know every bit of the case basis on the documents which are brought before me. I have been following a process that is called, in fact, lately I realized that it is called Kaplan opening. Neil Kaplan is a very big legal arbitration personality. He calls it Kaplan opening. What I do is this: in the first procedural order, I'll direct the parties. First procedural hearing, that in 20 minutes you will tell me what is the dispute, what is your position, and why are you right. This is called case theory. And other side will also tell me the same thing. However, generally what happens is, even basis on the legal notices, by the time they come before me, I would be knowing the dispute and I would be knowing who is right, what is their position. So I in fact tell them, this is your position, this is your position, have you anything to add to it? This is how you should start the process, so that you remain in command of and control of the proceeding as arbitrator throughout the arbitration proceeding. Have you ever observed what these judges do here in arbitration? Cross-examination, during cross-examination. They think that their only role is to correct grammar. So when lawyer will ask a question, they say, no, I put it to you. Okay. When the witness answers the question, if there is a grammatical error, they'll correct that. They think that is their role. I'm sorry. Cross-examination is not meant for this. Cross-examination is meant for something else. Cross-examination is a process where arbitrator is educated, is to be educated. This is what cross-examiners must know. In cross-examination, arbitrator must get their confusions clarified. They don't do it here because they have not read the file. Though they will charge you file reading as well. So, how to go about this? And can we simply complain about this here, sitting here in this hall or in other halls? No. And this is where I'll urge you. I'll urge this organization to start giving accreditation to arbitrators. Have a panel of arbitrators. For that, 2-3 things can be done. One, a structured program where one thing which arbitrators must know and every arbitration lawyer must know is awareness about soft laws. In India, most of the arbitrators are completely unaware of international best practices. For them, arbitration is no different from court litigation. Soft laws. What are those soft laws? These are protocols, guidelines issued by ICC Paris, Chartered Institute of Arbitrators has got lots of protocols. IBA, International Bar Association, has got a lot of protocols. Now if you see your Arbitration and Conciliation Act, here you have Schedule 5 and Schedule 7. Arbitrators should not have acted for the parties for 3 years and so on and so forth. Where from they got it? It is IBA guideline on conflict of interest which was there in international arbitration world for donkey years. This is what has been brought here. So in fact, Arbitration Bar of India, and this is where I'll take up this issue, because Arbitration Bar of India has constituted a task force, and I have been made the co-chair to prepare a protocol on construction arbitration. So it will obviously take care of shipbuilding and other aspects. But why can't we have a protocol on maritime arbitration? This protocol which I am working on is largely going to help all arbitrations, all arbitrators, all lawyers, in whether it is commercial arbitration, whether it is maritime arbitration, whether it's construction arbitration. And I am hoping to launch it in December first week, 5th, 6th and 7th, when I am organizing the world's biggest construction law conference, which I organize biennially in India as founder and chairman of Society of Construction Law India. Last time also we had 42 foreign speakers, all top level people. So we talk about this. So one aspect, apart from accreditation, for that, when we talk about accreditation, what is that we need to talk about? We need to tell them what should be the protocol, how appointments are to be accepted. People are unaware of international best practices, how arbitration is to be conducted, how PO1 is to be prepared, how peace is to be agreed or disagreed, all of this, how to conduct arbitration, totality. But for arbitration, another problem which I have seen is that award writing is a problem sometimes for non-legal people of non-legal background. They do it sometimes by copying somebody else's style, or sometimes they do it by trial and error. But in any case, they really invest lots of time on mere structure as to how to write this, even if they know the answer. So, like Chartered Institute of Arbitrators, for their fellowship program, if you want to have their fellowship, they have something called award writing. So, for your accreditation program, apart from talking about maritime law, pure maritime law, and arbitration, there should be a session on award writing. Then you should have, after that happens, once you talk about award writing in class, and then you give them the proposition, they write it, sit with you, correct it, once for all, all these confusion when you are writing the award goes in thin air. And it also tell you what all to consider. Otherwise, what happens, award would be not enforceable and it will be set aside even if you have done everything possible for do that. So, what I would urge all of you here is, think of arbitration, maritime arbitration, as additional, if not alternative, or alternative career option in all the capacities, and have some programs where you can think about all these accreditations, few lectures on how to conduct arbitration, one lecture on cross-examination, one lecture on the basic laws which you should keep in mind, and then see how your career really helps you in big way. Thank you very much.
So thank you, Professor Ratan K. Singh. You brought out a lot of important aspects regarding capacity building with respect to maritime laws and maritime dispute resolution. And we also have on the panel today Professor Risham Garg, and he would like to highlight how India's maritime growth is closely linked to this field and how we need to consolidate this capacity building in various domains, not only in academic and professional domains, but in other areas where we can spur the maritime growth, consolidating this field. So, Professor Garg, please.
Thank you. Okay, so thank you, Professor Shishir. Thank you. I would like to thank the RIS for inviting me to this topical discussion and discourse, and it's always difficult to speak after a stalwart like Shri Ratan Singh Ji. I have prepared one PPT which I may have the liberty of sharing with you. Okay, so right, it's slightly slow. I'll try. Yeah. So, how much time can I take?
We started late, but we can finish in 15 minutes or so.
Right. Okay. So, is a lot of thoughts given by Ratan Singh Ji. I'll start with some fundamentals. You know, I'm a student researcher of law, and I always like to focus on some fundamentals first. So there is a PPT. It may work, it may not work. Yeah, it's okay, right? Slightly slow, but we'll manage. So maritime. So the topic is maritime dispute resolution, and in the previous few minutes we heard the eloquent discourse upon role of maritime arbitration, and that ad hoc arbitration is very workable and is preferred. So you know, it has, so arbitration or dispute resolution has to work, right? So it may be institutional or ad hoc, and both will have their pros and cons. And certainly there are some key aspects that we need to consider. For example, we need to be mindful of the conflict of interest issues also. There is a lot of procedural issues at the stage of conflict of interest, you know. So there is an arbitrator or a counsel who has been an advisor or a counsel of a party, and then whether to what extent that relation goes, which they have to disclose, or they should recuse themselves from the tribunal. So some aspects were really music to my ears. For example, he did mention that professors may be involved in arbitration in three ways: one as experts cited for views and opinion, and then certainly sit as an arbitrator. So fortunately, I have had the experience and exposure to sitting in arbitration. Also, it's not only in moot competitions, moots, international moot, but also some real life arbitration and mediation as well. But that's really interesting. It is quite common in some European countries, but not so in India. And so as far as the issue is, experts to be cited for views on our opinion, well, this is slightly opaque. We will not get to know let's say, the legal issues. In case this matter of arbitration does not go on to appeal, only then it will become public. So that there is a limitation in which we can comment. which is not so there in some other countries. So it's just that some arbitration institutions do provide for redacted awards, and they do regularly publish some awards in a redacted manner, and in case there are no confidentiality issues, so that can become the basis for writing views and opinions. And two very interesting elements he did discuss regarding cross-examination and the Kaplan approach, which is the case management system. So the case management system is there in the Commercial Courts Act also. And interestingly, I have heard in my discussion from district court judges that the Commercial Courts Act provides a mandatory PIMS, pre-institution mediation, but when the case starts, so the parties are referred to mediation. At that time, the lawyers do not have that interest in settling or resolving the dispute. But when the hearing starts, certainly the judge will write that case management schedule with the dates and all. And when the time comes for cross-examination, apparently some lawyers develop cold feet because they are not comfortable in cross-examination, and at that stage they go for settlement. So it's very crucial, and cross-examination is not law, it is an art, and you should really focus upon it. Okay, so I will now have some thoughts on the paper that was circulated, which was with respect to this MSc case, which we had these two collisions in the seas near India, so Kochi. So what is the status of maritime law in India? So one aspect you have heard regarding the maritime arbitration, but another element of dispute resolution is litigation in the courts. And in India we have the Maritime Admiralty Act of 2017. Some courts have admiralty jurisdiction, which are mostly along the coastline, and they follow the arbitration, the Maritime Act. Before this act, we were following the previous Maritime Act, which was British Act, and the law was more or less the same. So now the problem is that when we look at these figures, so what is the claim? So whoever is the claimant, the party filing the suit, they have to lodge the claim. So what are the grounds of this claim? The government has asked for approximately 8,600 crores for environment pollution and damage, then approximately 378 crores for restorative and preventive measures, and then around 500 crores for economic loss to fishing community, all around 9.5 thousand crores. And that is the claim that they have filed, and this will be now going on in the litigation in the court, the Admiralty Court in Kerala. And we have not adopted some international conventions. We did not ratify that international law. So it will be a task. So what are the immediate problems? So like we faced in several situations, like Bhopal also, there is an accident and the remedy has to be done, but then the government functionaries, they will ask for who will give the money. Government is not going to give the money. So are they going to wait for the money? And then only after several years, the government thought of that, insurance fund, which has to cater to these sort of hazardous accidents. So who is going to pay? And the remedy, the solution, what has been adopted is to arrest the sister ship, so you can coerce the owners to pay something. So it's first of all the interim relief for the money which is being spent to which is to be given as compensation to the fishermen or the affected people, and then also to the environment damage. The remedial measures are being taken up. There is some chemicals which has to be set up. Then some conventions do have some limitation. For example, there is when we read contract, there is a limitation of liability clause, and in this limitation of liability for Maritime Claims Convention (LLMC), it sets a cap on ship owners' liability to 125 crore, but here it is thousands, maybe around 8,000 crore. So this how is this going to match up? This is far below Kerala's claim. So one element which we see here is that how do we navigate through these conventions and manage the claim and the remedies. So these are some applicable conventions to this the ELSA accident, and the case significance is the potential precedents in maritime law, impact on shipping disasters, certainly. So this is the timeline. Most of us would be aware, but just it's there. So the accident happened, and there is a spill. There are chemicals. It has to be contained. Some money has to be spent. Who is spending that money? Whether the government is doing enough, or they're waiting who is going to give the money. Whether the ship owner is going to pay an interim fund or not. Well, that's not going to happen till the time of settlement. And big lawyers, we have seen in the case of Bhopal case, big lawyers did force the government to come to a settlement. We thought that the government, when they will arrest these ships, the companies can be brought to settlement, but it happened the other way in the Bhopal gas. The initial claim, when the US court returned that or refused to hear that case, the US court in New York, they said that Union Carbide had to be willing to pay up to $3 billion, but the settlement here in India was $700 million, which is approximately 8 times less than what they could have expected to be paid. So there are several issues which we need to be mindful of. There are these conventions. So I'll just go to.
You may like to highlight India's gaps and where we are.
Right. So I've highlighted that there is a need for this compensation framework. For after the Bhopal gas case, there was this insurance fund which was created. So similarly, immediate money is required. So some compensation framework is required, and we can refer to certain best practices. Then there is need for a boost to surveillance mechanisms. Then regarding the jurisdiction and applicable courts, and certainly the applicable law as well. So we have the Admiralty courts, the specialist courts who will look into these matters. Right. So I will just. So this is a comparative chart. What we can adopt as the best practices, which is referred as best practices from these jurisdictions. So as far as the investigation is concerned, UK has a system, independent authority for investigation, then reporting protocols referred from Singapore. Even Malaysia has some protocols which is slightly better. Environment response unit. So environment response is very critical in these situations. Then treaty ratification. So what is the apprehension in ratifying these treaties? Then regional cooperation and the public discourse and discussion. So one very crucial element which was again highlighted by in the previous discussion was the treaties, the hard law and the soft law. And we must all understand that this is all international trade, international business, and business people want harmonized law or unified law, or they want to reduce the legal cost. So the role of let's say UNCITRAL or these treaties and soft law efforts of harmonization and unification is addressed towards reducing these legal costs, streamlining the law to make it, let's say, international or let's say similar in several jurisdictions, so it will not be complicated for the lawyers. It will not increase the legal cost for the parties. So treaties are good. It's a hard law. However, the soft law in the form of model law is also good. Like for example, the Arbitration and Conciliation Act. So this is the best example for the treaty law and the model law. We drafted the Arbitration Act upon the model law. So the model law on international commercial arbitration was referred to draft the Arbitration Act. Then the New York Convention for enforcement recognition of foreign arbitration award, we have adopted that image as it is as the act, the New York Convention Act of 1971, so that enables the recognition and enforcement of foreign arbitration awards as judgments. Otherwise, the foreign judgments are recognized as per the CPC provisions, section 13, 14, and 44A. So this is the what they call as the I'll just have to move. This is the Maritime India Vision. So the government of India has this Maritime India Vision 2030, which was, I think, released last year. So they want to. So the government has, we want to capture this maritime economy. It's a huge business, and so this is the roadmap which is shared by the government in that document. It's a 300-page document regarding maritime commerce. However, I was not able to find much regarding law and policy. So right. So now, fortunately, I am also a task force member on ease of doing business with the CII, the Confederation of Indian Industry, and I am able to provide some, engage in some discussions on that. I think this is all which I wanted to say in the given time. So apologies for rushing through, and these are slightly complicated concepts, but I hope this should be sufficient. And thank you for the patient audience, and thank you, Dr. Shishir, for this kind invite.
Thank you, Professor Garg. I think the two speakers have set the tone right for very inquisitive audience to ask you can ask some difficult questions to them. They are ready to face them. Yeah, please.
Thank you very much for this insightful lecture, both of these speakers. My name is Akash Gupta. I'm an associate professor at Jindal, and I teach arbitration there. So there are two questions. The first question is from my side, and the second question is a question from my student side, which is a most frequently asked question. So the first question is, India International Arbitration Center has recently came up with something called India International Maritime Dispute Resolution Center, which is going to be situated in Mumbai, which is almost going to be under the aegis of IIAC. Now, this is what is going to happen with a partnership with Ministry of Ports, Shipping and Waterways. Now, this is the structure which has been already followed in the South Korean industry. So, KCAB had a subsidiary. Later on, they realized after 20 years that maybe they should give the independence to the Maritime Arbitration Center, which was working within KCAB. A similar thing also happened with the Singapore International Arbitration Center. They had, in 2004, set up this Maritime Arbitration Center under SEAC. 2009, they realized that we have to give them an independent center. 2009. Now, let's cut it short to 2025. India is following a trend which has been already set up, that why don't you start with something like this. Now, another example within the Indian jurisdiction is the Gujarat International International Arbitration Center, which is under the aegis of Gujarat Maritime University. If we go to both of these websites, the problem is you'll not find the number of arbitrators who are the maritime arbitrators. What sir has talked about, accreditations or the courses through which any of us sitting in this room can be accredited, or you get the appointments. So what do you think if India has to carve out a way to become at least a South Asia hub for maritime arbitration? What is the way forward for this? This is the first question. The second question is a related question with respect to accreditation, which Singh sir actually talked about. So in all these places, we talk about accreditation, training, awareness, all of this. Now the frequently asked question from the student side is, even if we do this course, do this accreditation, let's say CMEC says that this is the program which you do, you get the accreditation. I say the problem is not accreditation or the training. The problem is whether we get an appointment even after having an accreditation. A classic example for this is Chartered Institute of Arbitrators. If you have the money, and of course you you have the basic knowledge, you can do the training, you become a fellow. Now the problem is, even if you become a fellow of CIR, whether you get an appointment as an arbitrator, nobody talks about. So these are my two questions to both the panelists. Thank you.
Good questions, good comments, Akash. See, this exercise, which has been done in Mumbai, in association with, I would say, and IIAC, India International Arbitration Center, Justice Hemant Gupta was also there. Question is, merely because government can open an institution or fund an institution or can come out with an enactment or can take care of the expenses, does not make any particular jurisdiction or seat as a hub of arbitration. IIAC is now in existence for quite some time. But when IIC was brought into existence, and the way it was brought in existence, the real stakeholders, and particularly the foreign disputants, had serious concerns about the role of the government in setting up of this. Merely because you have seen the success of SIAC in Singapore, or HKIC in Hong Kong, or AIAC in Malaysia, doesn't mean that how it worked there was, it was the combined effort of executive, legislature, and the judiciary. They came out with the policy to set up an institution which will be a national or a state institution. But government was kept far away from these centers. They are independent in real and true sense. If you see the court of these institutions, the governing bodies of this institution, if you see the constitution where people from all across the globe are brought on the board, government is completely away from it. Secondly, judiciary helps them in big way. What has happened to IIAC? Have you seen every single day Delhi High Court is referring at least more than 100 references. Where those references are going? Are they going to IIC? Not at all. It is going to DIAC, Delhi International Arbitration Center, or it is going somewhere else. So, one thing. Secondly, if you really wanted to make it an international arbitration center, then you were supposed to have global representation of people with integrity and reputation on the board. You have picked up few people, good people. I know all of them, very good friends, but that's not enough. Supreme Court of India ought to have sent all the international arbitrations which they refer while sitting in Supreme Court, because for international arbitration you have to go to Supreme Court. Are they sending this? So what IIC is left with? Small cases, not big cases. It is there for long. So question is, this is not how it works, but your question was how to make India an arbitration hub? Chartered Institute of Arbitrators, London. I am their director for last 14 years in India, and I am their fellow for donkey years. While celebrating their century, they came out with 10 commandments. That tells you, and that those 10 commandments in 10 lines were written by top level people from all across the globe, sitting together for months and months together to come out with 10 points which people look at, 10 things which people look at. Independence of judiciary, the quality of the bar, quality of arbitrators, ease of visa. So those 10 commandments, which were prepared by really top level people, You need to implement that. That's again not happening. And last thing, what arbitration community doesn't want is annulment of awards. But at the same time, what they also don't want is to bear the burden of bad awards. Now, this is a tricky situation. How to answer that? Answer lies in quality of awards. If you see the awards written here by people who have no domain knowledge, are not worth the paper even on which it is written. Almost all the awards are worth nothing. Now, therefore, result is the rate of annulment of awards in India is much higher than your neighboring countries. Now, question is, so when we talk about arbitration, when we talk about arbitration in India on big platform, everybody says arbitration is something where parties have chosen to go there. You should respect, don't interfere with the award. But what to do with those awards which are not worth the paper on which it is written? So, how to do that? And once I gave this suggestion while I was speaking in a conference and Justice Gawai was sitting there, I said follow a simple way forward. Way forward is, last year, I was in Singapore and I was invited in the Singapore Supreme Court in ISCL event where Justice Philip Jeratnam is also our part of co-fellow, and Justice Sundaresh Menon is also our co-fellow in ISCL. What had happened was this: they have a simple situation. For all specialized field subjects like construction law, maritime law, IPR law, their courts, their High Court and Court of Appeal together is called Supreme Court. What they do? They give accreditation to those lawyers who are practicing those subjects. Means people who are really good in the subject, they are recognized, given accreditation. What happens? What is the result of it? Result of it is they are accredited. Tomorrow you have some dispute and you want to have a lawyer, you may not know. Sometimes people think that lawyers are lawyers, every lawyer can do everything. No. So you have a list of accredited lawyers, go to the lawyer. So you are represented properly by the lawyers who know the subject. They have a specialist division, they conduct the cases properly. And tomorrow, when it comes to bringing people on the bench as a judges, those accredited people, lawyers, who have practiced that subject are brought there. And tomorrow when they retire, they become a good arbitrator. Simple. In TCC, in Technology and Construction Court, where all your disputes, maritime disputes are decided, in London, what they do? From my chambers, many of my chamber people from Keating Chambers, London, were their judges. So what they do is, people who have practiced that subject, they'll be requested to go there, either on a permanent position or as ad hoc judges. Alexander Nishan, who was the head of my chamber, till few months back, 2-3 months back, he was ad hoc judge there. So unless you bring quality in the decision making, certainty in the decisions, so that you can meet the expectations of the disputing parties, you can never ever think of becoming hub just because you advertise that you want to become a hub of arbitration.
So Professor Ratan Singh has taken up on himself, he's agreed prior to this, we had conversation, and he's agreed to help us build this capacity building. And during his talk he also mentioned about developing a protocol on maritime arbitration, and of course accreditation and other aspects which he just mentioned. So sir, I'm sure with all these efforts, right from classes on award writing to developing a protocol on maritime arbitration, and thereafter accreditation and developing capacities, I'm sure all of this will help our country and bring in quality. So any important question?
There.
Yeah.
Thank you, Professor, for this insightful lecture. I am Subodh. research associate at Indian Council of World Affairs. I look on Nepal and Bhutan. My question is, being landlocked countries, Nepal and Bhutan use Indian land and seaports for its overseas trade. So, what are the rights, like maritime rights, these two countries have with regard to trade and commerce in particular and in general as well, and what obligations they do as well, since the trade and commerce mostly just happen through the transshipment, the private sector involved in transshipment and all, and so when such kind of events happen, and when any kind of violation of maritime rules and regulations and laws happens, are they be called for being like a party to this, and will they be able to defend themselves in the court, or the private sector is likely to be this party? Thanks.
Professor, want to?
Okay, so thank you for that interesting question. So there are international treaties with respect to the rights of landlocked states to access the seaports for maritime trade. And as far as the issue of Bhutan and Nepal is concerned, it is a matter of mostly the bilateral relations between India and those two countries.
I'll tell you one thing very interesting. You talked about Nepal. 2014 or 2012, I was invited to speak in Nepal Supreme Court. And I was amazed to know there. So I gave a talk to the judges there, and then I gave talk to the bar, Nepal Supreme Court Bar Association. Then they took me to one center, that is a mediation center. They call it Saja Mel Milap or something they call it. And I was amazed to know during that period they had Mediation Act. We have just brought this here. So mediation has worked very well there, and this is a good sign. Yeah.
Sorry, just I'm curious much about this, because recently what happened that in Nepal's one of the policy document of government states about that they will be exploring more maritime areas, and because they are landlocked countries, especially Nepal and Bhutan, but Nepal's recent one of the government documents states that they will be exploring maritime. So in that context, I was trying to know something. What could be the
So we have a forum, BIMSTEC forum, where both these countries are there. We also have various protocols with neighboring countries, and at regional forums we do have partnerships where these landlocked countries. It is not a unique situation only in the Indian subcontinent. It is also there in Africa and other continents also. And all these landlocked nations do depend on their neighboring partners who have coastal zones, and then there are protocols and treaties with respect to that, and then there are partnership forums like BIMSTEC where the coastal countries help them out with their cargo movement. Yes. We also have an expert from the Ministry of Port Shipping and Waterways. The director, Mr. Mrityunjay Jha, is there in case you want to enlighten the audience about something on this aspect.
No, actually, it was quite interesting to be here. So I don't have any specific question. But if someone has got some specific question, I will try to.
Yes, he is also a law graduate.
Oh.
Yeah. So, shall we close?
Yes, I think there's no question.
Thank you so much for your good time. Yeah, please.
Regarding the court has a negative perspective regarding the settlement of the disputes. This maritime dispute other disputes, what is the average time for the resolution of these cases? Because what is the average time I want means how much time it will take?
There is nothing like average time in Indian judicial system. So, so I'll tell you, courts are not reluctant to promote amicable settlement. That's not the very correct statement. Courts do encourage, and now with the new regime, but your Chief Justice of India has given a lot of emphasis on mediation, and all previous Chief Justices have also given. Only difficulty is, and this is where I have a comment to make as the last point. What is happening is in India, everybody wants to promote mediation, Supreme Court, High Courts, all courts. Problem is, and then mediators are being trained also by the court annexed mediation centers or other mediation centers. But problem is all those mediators have got the expertise to only mediate family disputes, disputes between wife and husband, property disputes. If you really want to promote mediation in maritime sector, then you will have to promote from within those people who know the subject, who know the industry. Then they have to undergo mediation training programs where they give you a structured learning. And if you want, I can give you a fantastic mediation trainer who can come and sit with you. See, it is all about knowing the subject. It is all about giving alternatives to the parties to resolve and know how this whole system of mediation works. If Dr. Sisir would ever want me to do that, I'll give you a very good mediation trainer who can sit with all of you and talk about it.
Probably we need to, we were just discussing before the talk that probably India has to take lead as part of Global South to start an international center and start capacity building in mediation and negotiations before that, and especially in the maritime field, because that's growing for India and we need experts in this field. And thank you for this suggestion and offer, sir. So with this, I think that time is growing. We will, have these questions post the formal session is over. So thank you very much. In a very, very traditional style, let us thank the two learned speakers. I also take this opportunity to, honor them with a very traditional.
Oh, Asmi. Thank you very much. Thank you. साथ में
Thank you so much, and keep taking interest in such topics for capacity building. This is the real way forward for our growth.